Hello, everyone. This is Sarah Hellman. I am a partner in Husch Blackwell's Higher Education Group. We are very excited today to give today's presentation on alcohol and drugs on campus and in the workplace. However, before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons that you can use during the program today. And I just want to take a minute to show you a few of those or highlight a few of them for you. If you have any questions today during the webcast, please submit your question via the question box. We will try to answer all the questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later via email. We really appreciate audience participation and encourage you to submit questions. If you have any technical difficulty, please click on the help icon. It has a question mark and provides information regarding common technical issues. A copy of today's slide deck is available in the resource list icon. It looks like a folder at the bottom of your screen. And this program has been approved for Colorado, Illinois, Indiana, Iowa, Kansas, Missouri, Nebraska, Tennessee, Texas, and Wisconsin CLE credits. In order to report your hours in Illinois, Indiana, Kansas, Nebraska, Tennessee, or Texas, click on the CLE widget at the bottom of your screen and complete the questions. And certainly if you have any follow-up questions about the states, I know I went through a large list, just let us know. A recording of the webcast will also be available tomorrow for watching and sharing. And once available, a link to the recording will be emailed to you along with the certificate of attendance. So joining me today is Kate Levesque and Alex Rushing. Kate is a partner in our Healthcare, Life Science, and Education team and focuses her practice on labor and employment law. Alex is an attorney in our Higher Education Group and regularly counsels education clients on litigation, investigation, and compliance issues. Today we're going to be covering a couple of different topics. Alex Rushing is going to start from the student's perspective, and specifically, how does your institution protect your students from alcohol and drug abuse? Kate Levesque is then going to take it from the faculty and staff perspective and how institutions can respect the privacy of the staff without ignoring the need to follow federal guidelines. Finally, I'm going to take a look at a couple of real life scenarios and the results of some litigation as well as investigations by the Department of Education. So with that, I'm going to turn it over to Alex Rushing.
Thank you, Sarah. So we're going to start out this section on issues involving students and alcohol and other drugs by discussing some of the big picture concerns related to alcohol and drugs on campus. As most of you know, binge drinking is increasing and higher among college students than their non-college peers. Also, daily marijuana use among college students is also on the rise. This screen demonstrates some of those statistics that we just went over. But as many of you know, this is not just a drinking and marijuana issue. Non-prescription narcotics and prescription drug use is also on the rise. And you'll see on this particular screen, it goes over some of those statistics as well. Now let's dive a little bit into the law on this issue. The Drug-Free Schools and Communities Act of 1989 requires all higher education institutions that receive federal funding to certify with the Secretary of the U.S. Department of Education that it has adopted and implemented a drug and alcohol abuse prevention program, which we typically refer to as a DAP. That's how I'll be referring to it during the course of this presentation. This slide discusses what the goal behind the DAP is and its design, but something I want to focus on for all of you is to keep in mind that the area covered by your DAP is not just the campus itself, but also includes, for example, fraternity or sorority houses that are not on campus, but that are officially recognized by your institution. Here on the next slide are 3 of the 5 DAP elements. The first thing I want to highlight on this particular slide is the word unlawful, as it's used in that very first element. This is a minimum standard and certainly does not limit the scope of a school's standard of conduct. So for example, your school can choose to run a completely dry campus or implement a wider AOD policy to limit the lawful use of alcohol and other drugs on your campus. This is just the minimum standard. Later on, we will talk about some of the big changes in marijuana laws, but it's worth mentioning here too that cannabis possession, use, and distribution is still illegal under federal law and must be included in a comprehensive DAP regardless of your state's laws on this issue. And this is an ever-changing topic, like I said, that we'll discuss both on the student side and the employment side as the presentation continues. Here on this slide, you'll see the other two elements of the DAP that you should consider when you're reviewing your alcohol and other drugs or AOD policies. These are the 5 elements that should be covered by your institution, and so this serves as a really nice checklist for all of you when reviewing your AOD policy. And we'll talk about that review process a little bit later on. Notification is the next important piece of this puzzle. Institutions have to be sure that both students and employees are annually notified about the DAP information that was listed on those previous slides that we talked about those elements. Kate will dive a little deeper into the employee side of things, but from the student perspective, I want to make sure that you all are aware that this applies to all students enrolled for credit, regardless of full-time or part-time status. In our practice, we know that this usually means coordinating using a team approach that spans many different departments within our client schools. This is especially true if a student, let's say for example, enrolls during the semester that missed the initial distribution. He or she still has to receive the materials, and so we always advise our clients to have an action plan in place on how to distribute the DAP materials to students like the example that I just described. That way we're making sure that we're covering all of our bases. This slide covers some other suggestions and things to consider related to your DAP notification, including frequently read documents and other things to consider. We know that email is the most frequently used method to mass distribute this information, but keep in mind it's really not a perfect system. So I typically make sure our clients have a backup plan in place, like good old-fashioned snail mail to supplement. All institutions should plan on reviewing their DAP and the ways in which it is distributed at a minimum every 2 years. This slide lists out the items that, like I said, at a minimum should be included in that review. Again, it's 5 elements to consider during that biennial review process. These reports should be kept on file for at least 3 years after completion, just in case you get audited from the Department of Ed. For these audits and reviews of the DAP, consistency and sanction enforcement is really the key. Schools should be able to present data showing that there is consistency in enforcement of their policies. If there isn't consistency, then you should be sure that consistency is a goal for future DAP programming. That's what we typically recommend if consistency is something that you're not seeing within your results. So you may be asking yourself, when is the best time to update my institution's alcohol and other drug policy? Well, typically we explain to our clients that biennial reviews are a great time to change your AOD policies, but that doesn't mean that you should wait if there's a change in the law or a new prevention strategy that you know needs to be in there. So certainly not waiting if something has changed or if philosophically there's a new strategy you want to include. We list on this slide a change in marijuana law, for example, if that's something you wanted to highlight that is still prohibited under your policy despite a change in state law. But it's certainly something that at the biennial stage we recommend everybody double check. It's just a good time to double check that piece. Now we're going to discuss the ever-changing topic of marijuana. We will discuss it from the federal side and then also some state-specific issues to keep in mind. Again, my piece will focus on the student perspective, and Kate will talk a little bit about the employment side of things as well. As I mentioned earlier, marijuana is still illegal under federal law, despite now being legal recreationally in 8 states. Therefore, it still needs to be included in your institution's AOD considerations, including in your DAP. This is a really important piece that I think commonly some people don't know about. I think most of our folks on the line understand this concept, but it's worth highlighting just in case. So this slide deals with the differences between the administrations, the Obama administration and the Trump administration. During the previous administration, the Department of Justice agreed to not prosecute these offenses in most circumstances and to defer to state law. President Trump's administration has taken a very different approach to this topic. This past January, Attorney General Jeff Sessions sent a memorandum to all the U.S. attorneys demonstrating the DOJ's willingness to enforce federal marijuana laws. Again, this is just to give you a national perspective on this issue, but does not change how you all enforce this at your institutions, but rather talks about how the DOJ enforces it outside of your campus and in the general population. The next couple slides, we will talk about some state-specific laws that impact the states where we typically practice a lot in here with our St. Louis team. Starting with our home state of Missouri, we see several Missourians who are on the call today, so welcome. It is illegal according to state law. However, there are still several different campaigns to include medical marijuana on the ballot for this fall, and that's something that our higher education team as well as our marijuana law team will all be monitoring to see how that changes within the states where we practice and how it changes nationwide. Our sister state across the river has a pilot program related to medicinal cannabis use. Illinois' medical conditions are fairly narrow in terms of the use and appropriate use. So for example, there's no marijuana that's permitted for pain or PTSD. However, there is some rumbling that Illinois is considering using marijuana to treat opioid addiction. This is another issue that we will continue monitoring from the state-specific and the federal law perspective, but keeping in mind that even if you fall under one of these states, it certainly is still prohibited under federal law and should still be covered within your institution's alcohol and other drugs policies. So this slide does a great job of demonstrating graphically the various states' laws related to where recreational marijuana use is legalized. You'll see those are the states in the dark green coloring. And then the states that are in that lighter green coloring, you'll see that's where marijuana medically is legalized. And then in the states that are colored gray, there's no law that's in place regarding legalizing marijuana. The one piece that I wanted to highlight that we noticed is there's no box denoting what the blue states stand for. So if you're in one of those states like Arizona or New Jersey, you'll see that your state is in a color that's not covered by that key. And what that means is that those are states where this particular source, the credit that's at the bottom of the slide, you'll see that's where that source thinks that legislation will pass through and that they anticipate that there will be something on the books this upcoming 2018 session related to either medicinal marijuana use or recreational use. Something to highlight that contrasts between, let's say, Arizona and our state of Missouri is even though Missouri, we anticipate having 3 different issues related to this on the ballot in the fall, Missouri is still considered a gray state where there are no laws legalizing marijuana. That's because this particular source does not anticipate any of those proposals to pass. And as a result, that state remained in that gray coloring. So for those of you who are on the call, we see people from all the various states within the union. It's really important to look at what your state-specific laws are, but always keeping in mind that it is prohibited under federal law. So this next slide shows an excerpt from the University of Colorado Boulder's alcohol and other drug policy. The reason we highlight this policy is because Colorado is obviously one of those states where marijuana is recreationally legal, but UC Boulder does a great job of pointing out to students that marijuana use on campus will not be tolerated regardless of the state's laws legalizing its use. So for those of you who fall within those 8 states recreationally or those other states where it's permitted medicinally, this is a great sample of what to potentially cover in your policies, calling out that specific distinction between federal and state law. This next slide highlights an issue that we expect to really increase in the coming years, especially under this administration. A student convicted for the possession or sale of illegal drugs may have financial aid eligibility suspended if that offense occurred while the student was receiving federal student aid, which is really why we highlighted that piece of the differences between the administrations. We anticipate that the Trump administration will enforce this much more rigorously than the Obama administration did, and so we may see more and more students who have these sorts of convictions who are receiving federal student aid while they're enrolled at our institution, so really keeping that issue in mind. The Government Accountability Office's report with the most recent data showed that 50,000 students in the 2013-2014 school year were denied federal aid due to their convictions, and we only anticipate that that number will increase over time. As we discussed in the beginning of this presentation, this issue is not one that is exclusive to alcohol and marijuana use. Opioids and other prescription drug use is also absolutely on the rise. The UC Boulder policy that we highlighted a couple slides ago was excellent for this issue too, because it was short, clear, and inclusive of not just illicit drugs, but also the misuse of prescription drugs, another area that, as I mentioned, will continue to increase. So that brings us to our very first poll question. And so for those of you who are watching and viewing, this is the question that's before you. If an institution posts its DAP information online and informs its students of its location, does it still comply with the Drug-Free Schools and Communities Act? And your choices are yes, no, or sometimes, my favorite lawyerly answer. And we'll give a few seconds for those of you to fill in your answer. I see the answers are slowly trickling in. We'll give a couple more seconds. Okay. So we had 17% that said yes, 57 or 58% that said no, and 25% said sometimes. So I'm guessing we've got 25% of you who are attorneys on this call. The answer is sometimes. Institutions of higher learning must send all students and employees all of the information about the DAP listed in the earlier slides. Sending an email or other document that provides a link to some of the information or to other broader school policies is not sufficient and could result in fines. To work, institutions must send a link to every possible recipient, and the link must take students and employees directly to the complete DAP information. So with that, I will turn it over to my colleague, Kate Levesque, who will talk about this issue related to the workplace and employees.
Thanks, Alex. I appreciate it. Alcohol and drugs in the workplace is something that has been discussed for years and years. This isn't a new topic, but the newness of it is that it's ever expanding and changing with the use of medical marijuana and recreational marijuana laws. So let's talk about some statistics. This topic is important because our workers are using drugs and alcohol at an increased rate. According to a 2016 survey, the National Survey on Drug Use and Health, 38% of young adults and 24% of adults are binge drinkers. And binge drinking was defined as having 5 or more drinks in one session within the past 30 days for men, or 4 or more drinks within the past 30 days for women. Interestingly, 10% of young adults and 6% of adults, which is 12.6 million adults, are heavy alcohol drinkers. And heavy drinking is defined as binge drinking on 5 or more days within the past 30 days. In addition, about 20% of young adults, so 1 in 5 young adults, are current marijuana users, according to this 2016 study, which is about 7.2 million, and about 15.2 million adults are marijuana users. And that is the highest level since the data collection started in 2002. And ever increasing is the 2.5 million adults that misuse pain relievers. So with this increased use that we're seeing, it's important that every institution of higher education have a DAP that not only covers students, but also a program that covers employees. And it's required. It's often forgot about that the DAP should also cover employees and should also be given on a yearly basis. It's often thought about that we need one of these for our students, but it's really important to remember that employees should also be covered. Employment policies can differ from the policies for students, but they should always include those 5 DAP elements. So it should include the standards that prevent unlawful possession, use, or distribution of illicit drugs and alcohol on the premises or as any part of the activities. It should include the legal sanctions, the health risks, the list of prevention programs, and the sanctions for violations. All of those were in Alex's slides. So all of those elements have to be in both the employment policy as well as the student policy. But the employment policy is often a lot more expansive. For example, an employment policy probably contains stipulations for drug testing in certain situations that are not normally included in student policies. Having said that, we do see some schools or some programs, specifically medical schools or nursing schools, that do include drug testing as part of their student AOD policies. So it's not completely unheard of to have some drug testing in the student side of things, but it is very common to have some drug testing on the employment side of things. And we'll talk about some of those common drug testing policies. The employees must receive the policies annually, just like the students should receive the policies annually. And so we should always remember to push those out to our employees at the same rate that we're pushing them out to our students, whether it's at the beginning of a new academic year or you decide to do it every January 1st, or however you really want to do this on the employment side of things, as long as they're coming out every year. So let's move to some best practices on the employment side of defense. The first thing that I always recommend that organizations or institutions do is to perform a needs assessment and determine what your institution requires for good compliance. Some institutions might need information or policies about operating company vehicles while under the influence, while other institutions don't need that type of information at all in their policies. So you always want to do a needs assessment on what are the activities that your employees are doing and what policies need to be tailored to that employment group. Also, you want to think through whether you require random testing or just reasonable suspicion testing or pre-employment and post-offer testing. And we'll talk about all of the different elements to those three types of testing a little bit later in my slides. The second thing that you always want to do is to have that written policy that complies with DAP. And you always want the policy to say that you will apply the consequences, and you need to apply them consistently. And that's one of the requirements of DAP, in addition to just a standard good practice. Even for organizations that are not higher institution organizations, that's something that we require in the policies, or that we strongly recommend in the policies, to have the consequences and to always be consistent. So you want to make sure that your policy is written in a manner and the prohibitions and the requirements are ones that you can follow. You don't just want to have lofty goals that you're not actually going to follow in practice. The next thing that you always want to do is supervisor training. Your supervisors and your managers are the eyes and the ears on the ground. Those are the individuals who are actually going to be seeing the violations of the policy most likely. And so you want those supervisors and managers to know what they're looking for, especially if they're involved in determining when someone should be sent for reasonable suspicion testing, or if they're responsible for implementing your random testing procedures. Because the key with random testing, as we'll talk about, is to make sure that it truly is random. And there are a lot of different ways that you can go about that we'll discuss. You also want to outline the procedures and the steps that your managers and your supervisors are going to follow when they do have a suspicion that an employee has violated the drug testing or drug and alcohol prevention policy. Next, you want to do some employee education. You never want to roll out these policies without your employees understanding what is prohibited. So whether you put that into your onboarding training that you do, or if you're rolling out a new policy, having some sort of a staff meeting or different departmental meetings, you always want to educate your employees about what your policy prohibits and the procedures that you're going to go through to make sure that the employees and the university is in compliance. The education should go through the legal risks associated with the use of alcohol and drugs, the health risks, and any consequences under the policy, so that employees can't later say that they didn't understand exactly what was prohibited or the consequences of violating the policy. Next, you want to think through exactly what type of drug testing you're going to do, and that we'll get into in depth in detail on the next slide. And then finally, you want to think through how your employee assistance program can help and whether you want to put one of those in place to the extent that you don't have one of those. The employee assistance program, you can reference the resources that are available to the employees and when EAP referrals will be made. For example, many of the policies that I've seen indicate that if an employee self-discloses an issue and requests assistance prior to a positive test, then the EAP will be available to assist. But unless state law prohibits, many organizations and institutions do not permit employees to avoid disciplinary action by requesting assistance from EAP after a positive drug test. Now, some states require that you give that before going to discipline or discharge, but in states that don't, many times employees are not permitted to avoid the consequences, so to speak, by requesting assistance after the fact. So let's talk about some common types of drug and alcohol testing. The first most common type is the post-offer and pre-employment testing. That is where employment is contingent upon passing the test. You cannot require an employee to go through, or a prospective employee to go through testing prior to giving the offer, but many employment offers are contingent upon the successful completion of a drug test. You want to make sure that you're applying this consistently. Either you're applying it to all employees across all jobs, or you're targeting specific departments or specific job titles. Some jobs and some states require pre-employment testing, and some universities make pre-employment testing a condition at all times, and some say, well, we're not going to do it for everyone, but we will test employees in security or other safety-sensitive jobs prior to, after a conditional offer of employment and prior to employment actually beginning. So that's the first most common type, and that's written into almost all employment policies. The second most common type of drug and alcohol testing is reasonable suspicion testing. And this is subjective and requires a fair amount of discretion, which makes it somewhat risky and really requires good training and policies and procedures for your supervisors and your managers to follow. Basically, this is the type of testing that's utilized when an employee appears to be impaired in the workplace. If you smell alcohol on someone's breath, if they are slurring their words, if they're unable to focus, sometimes even if they're falling asleep at their desk. This is the type of testing that you will utilize. And you want to make sure that you have policies and procedures in place that are consistent with the finding that you're giving that you reasonably believe someone is impaired at work. For example, requiring that they be driven straight to the testing site rather than driving themselves. Obviously, if you're concerned that someone is impaired at work, you don't want them driving themselves to the testing site. So you want to really think through how you're going to make this reasonable suspicion testing work in practice. Next is post-accident testing. This is fairly self-explanatory. It occurs after an accident occurs. But you should be careful because you want to limit this to only when you have a reasonable belief that alcohol or drugs could have contributed to the accident. In other words, if someone has, a small accident and you don't believe that alcohol or drugs could have contributed, we don't recommend that you use testing, and actually OSHA would indicate that you should not do testing at that point in time. Finally, there's random testing. This is rarely used. I see it a lot in manufacturing with manufacturing clients and some others, but it's rarely used in higher education, I would say, because it's often hard to have a truly random test. and it does have to be 100% random. So random doesn't mean you think that John Smith might be impaired, and so you randomly ask John Smith to go get tested. Random means all employees are put into some sort of a database, or their names are put into a hat, so to speak, and at various intervals that are set out in the policy, 5 employee names are selected, and it's always the same number that are selected at a given time, and the intervals can be random or could be set, but you always want to have that in the policy. There is a fair amount of risk if these are not implemented appropriately and they are not truly random. So we always advise our clients to be fairly stringent and to always seek legal advice when you're setting up some sort of a random policy. Always you want to tailor the type of testing that you're doing and the guidelines that you set out for the testing to your school's needs and your individual concerns. We never recommend that you just create or implement a policy that's overbroad or, on the other hand, is under-inclusive, because that can lead to other problems. So you always want to really think through what your needs are and the policies and procedures that you can actually accomplish and consistently administer. There are always statutes and regulations to consider with any of these sorts of testing policies and procedures, and so I'll talk a little bit about those. One common question that we always get is whether or not alcoholism or drug use is actually protected by the Americans with Disabilities Act and many of the state law equivalents to that. Alcoholism is protected. It is a protected disability, and so it is something that would be protected by the ADA. Drug use, employees are protected if they have successfully completed a rehabilitation program and they are no longer engaging in illegal use of drugs, or they are currently participating in rehab and they are no longer engaging in the illegal use of drugs, or if they are erroneously regarded as having engaged or currently engaging but they are not engaging in such use. So what that boils down to is the current use of illegal drugs is not protected under the ADA, but former use that has been completely rehabilitated, or the erroneous belief or having someone be regarded as a drug user who is not a drug user, that is protected. We often also get questions about prescription medications under the ADA. Many schools and colleges and universities have policies that employees should disclose the use of prescription medications, and that's generally risky. Asking all employees about their prescription medication is generally not job-related and consistent with business necessity, which is the requirement under the ADA. So asking about prescription drug use should be fairly limited. Sometimes you can demonstrate that it is job-related and consistent with business necessity. For example, employees in positions that are affecting public safety, they may need to report when they're taking medications that may affect their ability to perform the essential functions. In those limited circumstances, you may be able to demonstrate that the request for information on prescription medications is appropriate, but you should be very cautious in doing this. And we do not recommend that you have broad requirements that all employees report any use of prescription medication. It definitely gets into an ADA issue and is not recommended. Secondly, we talked a little bit about OSHA and the restrictions on drug testing after accidents. OSHA certainly acknowledges that maintaining a safe workplace is important, but they also have stated that a blanket policy of post-accident drug testing could constitute retaliation and could deter proper reporting of accidents and injuries. An employee may not report an accident or injury if he or she believes that she may be subjected to post-accident testing. And so in May of 2016, OSHA published a final rule that went into effect on December 1st of 2016. And that final rule basically prohibited the blanket policies of post-accident drug testing. And they have indicated that there has to be a reasonable possibility that drugs or alcohol could have contributed to the accident. There doesn't have to be specific indications in the particular fact situation. It just has to be the type of accident and whether alcohol or drugs could have contributed to that type of accident. So I'll give you an example. If an employee is outside and they get a bee sting, chances are alcohol or drugs could not have contributed to that specific accident, and so you would not send someone for testing. But if an employee falls down the stairs, then alcohol or drugs could have contributed to that, and it could be a reasonable possibility, and so you could get tested. The Department of Transportation also has some other regulations related to testing requirements for highly abused synthetic opioids that are not in other statutes. So to the extent the DOT regulations apply to some of your employees, you should be cautious of that. And then there are state statutes and regulations. Some of those have record-keeping requirements. Some require the type of labs that employers can use to do the drug testing. There are notice requirements in some of those statutes. There are restrictions on the ability to terminate employees, and there are restrictions on the ability to use positive test results in unemployment hearings. And so you always want to be very cautious of what your state in particular requires. For example, in Minnesota, Minnesota requires a confirmation test before you can discharge employees or withdraw an offer. You can suspend employees or transfer them pending the results of the confirmation test, but you can't discharge until after the confirmation test. And in addition, you can't discharge for a first offense unless the employee has been given an opportunity to participate in rehabilitation and either refuses or fails to complete the program. So state laws are definitely becoming more stringent on this issue. Talking about alcohol at work, as we talked about, alcoholism is covered by the ADA. It can be a protected disability that must be accommodated, but you don't have to accommodate alcohol-infused misconduct. And so you never have to, you can always take action for alcohol-related misconduct, even if it's related to the alcoholism. So if someone stops showing up for work or has a lot of no-call, no-shows, you don't have to accommodate that by ignoring the issue. In general, from what I've seen, a lot of the accommodations related to alcoholism are related to leave that's provided for treatment or care or counseling, rather than accommodating the actual misconduct that's occurring. Universities and colleges should also exercise care in serving alcohol at work functions. The legal liability related to the service of alcohol is analyzed under state law. Many times you hear about it as dram shop liability or social host liability. There's no liability, for example, in Missouri or Illinois for social hosts, but some states do allow direct liability for serving alcohol. And so you always want to be careful of which state you're in when you're serving alcohol at work-related functions. And as best practices, we recommend that employers avoid or limit the open bar, consider a cash bar or tickets, hire professional bartenders, obviously making attendance at any sort of events involving alcohol voluntary, making sure that you don't serve minors, and setting up perhaps a taxi service or Ubers or something like that to try to limit any sort of liability related to alcohol-related functions. Finally, we get a lot of questions about marijuana in the workplace, and this is ever evolving. But two of the big questions we get is whether an employer can discipline an employee for lawful off-duty medical marijuana use or recreational marijuana use in the states where that is permitted. And second, do you have to accommodate the medical marijuana use? In general, employers can discipline or discharge employees for off-duty marijuana use. Coates versus Dish Network was decided in 2015, and in that case, the plaintiff had engaged in lawful medical marijuana use. He had a medical marijuana card, but then tested positive. And the Supreme Court concluded that it was not lawful because using marijuana is still illegal under federal law, and so Dish Network had the right to fire him for the positive drug test. There is a recent case that came out in 2017 where, and that is the Nossinger case, where a former veteran with PTSD filed an employment discrimination action against his employer who refused to hire him after he tested positive for medical marijuana on the pre-employment screening test. This case is somewhat limited to the situation at hand, where what was actually said in the statute and how they were bringing the claim. But basically they said that the federal laws prohibiting the use of medical marijuana or any type of marijuana did not preempt the state law that permitted the use of medical marijuana and required employers not to discriminate. So it's yet to be seen how far that case will go. Secondly, does an employer have to accommodate an employee's medical marijuana use? Probably not, but you want to make sure that you're consistently applying your prohibition to all employees. You don't want to discharge someone for using marijuana, but give someone a second chance for using cocaine when they were using cocaine. You always want to make sure that you are being very consistent. And I put some cases down that talk about these issues in case any of the lawyers on the phone would like to go look them up. But there are some open questions, and I anticipate that we'll get even more litigation as time goes on. And that's a perfect segue, I guess, to Sarah Hellman talking about some real-life scenarios, investigations, and litigation.
So before we jump into the real-life scenarios, we've had a great flurry of questions come in, and always appreciate those questions coming through, so please keep them coming. And I wanted to follow up on some of the ones we received from the student perspective. So one of the questions related to medicinal marijuana use in Missouri, and on slide 17 is where we talked about marijuana use in Missouri state specifically. And that slide covered how there was a bill that passed the House in May 2018 approving the use of smokeless marijuana, so not what we typically think of marijuana use, but smokeless marijuana for some chronic and terminal illnesses. Again, this is a topic that continues to change in a lot of different states, including Missouri, so we will continue to monitor it. We have actually an entire team that follows and focuses on cannabis laws around the country, and so to the extent that any of you are interested in any of their webinars or blog posts, please feel free to reach out to Kate, Sarah, or I, and we would be happy to provide a link to any of that information that really dives deep into the various state laws and federal laws related to this issue. The other thing that came up that I wanted to talk about very briefly is related to the risk of financial aid eligibility. We covered that on some of our slides, and whether that notice should appear as a possible sanction to students. We typically don't see that appear, but some schools do have it. I would say the majority do not have that appear within their policies. So that's something for you all to consider if that's something you want to be all-inclusive about or not. And then the final question that we received related to more of a logistical piece regarding our broadcast. As Sarah mentioned in the beginning, this will be available for viewing and sharing tomorrow, and you'll receive a link so long as you subscribe to our webinar. If you have any difficulty with that link or have any other issues, please feel free to reach out to Sarah, me, or Kate, and we'd be happy to assist you with that. And with that, I will turn it over to Sarah Hellman to talk about real-life scenarios.
Thank you, Alex, and thank you, Kate. So now we're going to, look a little bit about how the use, the existence of alcohol and other drugs on campus can result, not just in litigation, but fines and investigations as well. And the scenarios that we're going to go through, which are in fact real-life scenarios, are very different factual patterns, but I think by examining some of these scenarios, it can help guide what you do and do not do. So we're going to start off with a poll question, which says, I should only be worried about litigation, and I'm actually going to throw in litigation and investigations, when my institution dismisses a student or employee for violating a drug or alcohol policy. So true or false? And we'll let those answers come in. I'll give just a couple of more minutes. We see some answers come in, some people still deciding, it looks like. And let's see, all right, you guys are right on. I think it was the word only. I think if you ever have, I should only be worried, it's always a clue it might be false. So the overwhelming majority of people answered false, and that's correct. It is false. In fact, the Department of Education conducts audits of CLARI Act programs and compliance with the Drug-Free School and Communities Act. And why is this? And I think this goes to a question that we've had from somebody in the audience. In 2012, the Department of Education issued a report concluding that there had not been sufficient oversight of the Drug-Free Schools and Communities Act requirements. It had been in effect at that point since 1989. So the Office of Federal Student Aid responded, and they responded with a corrective action plan that outlined a more concerted effort to investigate these violations in schools, and even those schools that do not participate in Title IX programs. And these audits are not necessarily prompted by suspicion of violations, while they may be. You know, any school that receives federal funding must reply to this request, the Federal Office of Federal Student Aid request to furnish documents showing that they both have an adequate gap and they conducted the reviews. And incomplete gaps and insufficient reviews can and have resulted in fines. So what have we seen, at least in the last year? According to the Department of Education, in the fiscal year 2017, about 5% of institution of higher learning review did not meet the requirements for a sufficient gap. And, you know, you may look at this and say it's only 5%, but, you know, as, you know, both Kate and Alex have alluded to earlier, you know, drug use is on the rise on campuses. We're seeing changing laws with marijuana and the legal or illegal nature of it. And I expect that as these laws continue to change and the use of, you know, both, you know, marijuana, cocaine, and prescription drugs increases, we're going to see continued investigation of the policies that institutions of higher learning have. So I thought we could take a look at least a couple of rulings that came out just last year. This is a college in California where the Department of Education found that they had violated the Drug-Free School and Community Act for not developing an adequate gap and not informing students about it and not conducting sufficient reviews. And I think this goes to the poll question that Alex had covered earlier about, you know, can you post it? How do you have to provide notice of it? And in this case, first of all, the Department of Education found that the school had failed to include a number of program elements. These are the same, you know, some of the 5 elements that Alex covered earlier in the program, including the health risks associated with the use of drugs and alcohol, the counseling, treatment, and rehabilitation available, and then the sanctions. And not only did the DAF not have the required elements, the college had merely sent out an email asking students and employees to read the handbook without providing a direct link to the required documents. And this goes directly to the poll question that Alex had. This was not enough because the school there had taken a passive approach versus the direct notice. The Department of Education also found that the college failed to assess the effectiveness of the DAP and therefore did not meet minimum standards. So the school had some other CLARI Act violations. They were fined $86,000, about $18,000 of it, which was the failure to comply with the DFSCA. Another ruling that interestingly came down the exact same month as the one we had just looked at involved South Carolina State University. And here, when asked for their materials, the university was only able to produce the university's drug-free workplace policy, which is completely separate than what is required under the DFSCA. So since they did not have the sufficient policies, the Department of Education also found that they clearly had not done a sufficient review of those policies. And here, the university was fined $15,000. And in the order, though, the Department of Education specifically noted that it's a serious violation because there's no way students and employees can make good use of a policy if it hasn't been published and distributed to them, which, sounds pretty logical, but it was something that they pointed out. And the fact that there was a failure to have such a policy, they noted it to be a serious violation. So these are a couple rulings that came as a result of investigation. We're going to turn now to some litigation. This is a case out of the 11th Circuit involving a university in Florida, where here the plaintiff had suffered severe depressive episodes that required him to go under psychiatric care. After and when he was in these depressive episodes, he also drank heavily. He was given extended leaves of absence, and when he came back after his second time being out, the Student Progress Committee had him sign basically a mandatory substance abuse, alcohol abuse agreement. Again, after he had signed the agreement, he again experienced these depressive episodes, had to go under psychiatric care, heavily abused alcohol, was gone from the program for weeks at a time. And ultimately, the Student Progress Committee dismissed the plaintiff from the school, and he brought an ADA claim, claiming that his depressive episode, he was in the protected class based on his depression. He actually did not claim the protected class of alcoholism. It was based on his depression. And the court here, determined that there was no ADA violation. They dismissed the complaint outright, and it was upheld by the 11th Circuit because it wasn't based on his disability, right? It was based on the violation of the alcohol and abuse agreement, and the school could require him to sign that as a basis for essentially readmission, because it wasn't required at the get-go. It was required after he had been out a number of times. Another case, which I think, kind of follows especially what Alex talked about in terms of developing a strong AOD policy. Here, the plaintiff in this case, it was a plaintiff that was expelled from school, argued that he should be, brought suit, that he should be reinstated to NYU because the sanction was too harsh for the offense. In other words, the policy and procedure wasn't fair. And in this case, there was a box found in his dorm room that contained several ounces of marijuana, about $1,000 in cash, and other drug paraphernalia that indicated that he may have been distributing drugs on campus. And what the court did is they went to the university's policy and said, did the university actually follow that policy? And here, that the student was informed from the policy that was handed out to all the students that what the consequences of violating the policy was and what the punishment was. And the court found that it was neither shocking nor disproportionate. And so I think the takeaway from this is, having a strong policy that outlines what's prohibited and what the consequences of, whatever that activity is that's prohibited, what are the consequences of that? And having that policy and actually following it, while, it may not prevent unwanted litigation, it will certainly help if there is litigation. The final case I want to look at is a very recent case in a federal court in Minnesota, and I think that this case is, it shows how and if, the issue of alcohol and other drugs on campus, how it connects with Title IX. In this case, what happens is the plaintiff there alleged that she was raped by fellow students on 2 different occasions, both of which involved substantial amounts of alcohol. And the plaintiff filed suit against the college, alleging that the college tolerated, they condoned, they enabled underage and excessive drinking, which I don't think anybody will argue, can lead to an increased risk of sexual assault. The plaintiff brought a number of claims for unintentional infliction of emotional distress claims, brought a breach of contract, but the one I want to talk about is the Title IX claim. And, as I'm sure you're all aware, a funding recipient of Title IX can be liable for student-on-student harassment. However, the plaintiff must show that the college had actual knowledge of the assaults and acted with deliberate indifference. And the court, she brought 2 claims under Title IX, one with the actual assaults, and the second one dealing with the college's response to the assaults and the rape. The first claim, the court dismissed because there was no evidence, or the plaintiff hadn't sufficiently alleged that the college had actual knowledge of the assault. And the court said, even assuming that this college knows underage drinking goes on, and even assuming this college knows that excessive drinking goes on, and even assuming that this will lead to an increased risk of a sexual assault, that is not enough to establish actual knowledge. Now, the court did allow the claim under Title IX to proceed in terms of the college's response to it and whether it was reasonable in light of the circumstances. But they did dismiss, the actual knowledge, even assuming that the college allowed this underage and excessive drinking to go on. So with that, and I know we're almost out of time, we're going to look a little bit to, what do we see happening? You've heard it from the student perspective, the employment perspective, and certainly the litigation perspective. So I'll kind of turn it back over to Alex and Kate to help wrap us up.
So some of the predictions that we anticipate are really increased issues related to criminal background and student conduct issues during the admissions process. This beyond the box, and on the employment side it's called ban the box, but on the admissions side it's beyond the box. We did a presentation last fall on this particular issue, and we think that this will only continue to increase, especially under this administration's increased enforcement of this issue as it relates to outside use off campus. And then the other increase that we've seen from our clients' perspective and across the board is really increased training combating these issues, because it's only increasing, and we think training is the big piece to hopefully decreasing it or at least mitigating some of the risks associated with it related to alcohol and drug use that is on campus.
From the employment perspective, we anticipate that there will be increased complaints about the use of medical marijuana in the workplace. We anticipate that more state legislatures of these acts and statutes allowing medical or recreational marijuana will try to mirror the Connecticut legislation to see if they can get around some of these issues with it being illegal under federal law but permitted under state law. And ultimately, I would anticipate that at least one of these cases is going to be litigated all the way up to the Supreme Court, and we'll see some type of definitive answer. Anytime you get some splits like this on a pretty important issue, we would anticipate that it would keep going up the trail. And then finally, and I mentioned this, I think we will see continued investigations about whether these policies are adequate, whether there are sufficient reviews. And certainly with all of that, you do tend to see an increased litigation on these issues. I mean, we've seen it with, the opioid crisis now, and I think we're going to continue to see it with whether it's opioids or something else. So with that, I think we may have a couple of questions and maybe a minute or two to answer.
Sure. We've got a couple questions. The first one is, if we have a student or employee that is using alcohol on campus, and that individual states that they suffer from depression, are they protected, or can we take action against that individual? In general, if the use of alcohol on campus is prohibited by your policies, it would not be a reasonable accommodation for an employee to say, hey, I have depression, so I need to use alcohol on your campus. You can still uniformly enforce your policies, and it would not be a reasonable accommodation for you to get around that, or for the employee to get around that. And the same is true on the student side of things. So you can still uniformly enforce your policies even if an employee suffers from a disability. The accommodation that you would want to offer for depression is something different than allowing them to violate your alcohol and drug policy. The second question that we have is whether or not an employer can have a policy that it will not pay for alcohol on employee or faculty expense reports, and that's certainly permitted. You do not have to allow your employees to drink when they are on work-related trips, and so you can certainly say that if they choose to do that on their own time, it needs to be charged to their own credit card, and that you will not pay for those sorts of expenses.
And the final question that we'll answer today is whether harm prevention programming can be used in marijuana prevention under your DAP, and that certainly could be used, and we see some of our schools using it currently.
And that is about time. I know we weren't able to answer all the questions, and we hope to get those to you via email. But thank you for joining our program today. We hope that the information provided was helpful for you and your organization. So if you have not already, please click on the survey icon at the bottom of your screen to complete our short survey. Your feedback assists us tremendously in providing quality future programs. And a reminder that it has been approved for CLE credit. Again, if you need the states, reach out to one of us because I know I went through a bunch of them with you. And the recording will be available tomorrow and for watching and sharing, and will be available for the next 2 weeks. And then finally, be sure to join us for our next webinar on September 26th on research compliance. And this concludes our webinar. Thank you, everyone. Have a great afternoon.